Good evening, everybody. We'll go ahead and get started. For those of you who don't know me, I'm Jim Anaya, the Dean of the University of Colorado Law School. I hope you're all doing well. Thank you for joining us for a lecture and a discussion in this installment of our Race in the Law series. This evening's program features Professor Kristen Carpenter, who will speak on race and religion, a case study on Indigenous peoples in the United States. Before we begin, I'd like to recognize that the University of Colorado is located upon land within the Ute, Cheyenne, and Arapaho peoples' territories. And further, we acknowledge that 48 contemporary Indigenous nations are historically tied to the lands that make up the state of Colorado. Before we begin, a few items to note. Your screen name should be listed as a first and last name. If it isn't, please update your file in the video settings or by the appropriate mechanism. I'm not sure exactly, but I think it's pretty simple. Your first and last name allows us to identify you so that you can receive credit in your CLE affidavit for those of you who are seeking CLE credit. You're invited to introduce yourself using the chat function by entering your name and any information about yourself that you'd like. This meeting has an interactive component, and following the Q&A, you will be randomly assigned to discuss the topics outlined in your program at cu.law/program, although I believe the decision has been made to make those topics fairly broad. We're grateful to the Native American Rights Fund, whose representatives will be assisting with the breakout sessions, and we're grateful for all the partnership endeavors that we've had with NARF over the years. During the presentation, you can ask questions using the chat function, and Professor Carpenter will respond to questions following her presentation. This evening, we are pleased to partner with the law school's chapter of the Native American Law Students Association, also known as NALSA. Thank you, Sasha Strong and Taylor Shedd, both 3 Ls, who will moderate the Q&A question. And it's great to have the participation of the other members of NALSA joining us this evening. The Race in the Law lecture series is a part of Colorado Law's anti-racism and representation initiative. An overarching goal of the initiative is to enhance opportunities for learning and reflecting on racism and its effects, and on what each of us can do to defeat racism as lawyers or future lawyers and citizens. And we're pursuing this goal in part through this lecture series. Other overarching goals of the initiative are to expand the law school's role as a catalyst for direct action to combat racism and its manifestation around us, and to enhance the representation and inclusion of people of color and others from marginalized groups within our law school and the legal profession. If you're interested in learning more about the initiative and our progress with it, I encourage you to look at our website at colorado.edu/law. It's now my pleasure to introduce my friend and colleague, Professor Kristen Carpenter, a Council Tree Professor of Law and Director of our American Indian Law Program. Professor Carpenter teaches and writes in the areas of property, cultural property, American Indian law, human rights, and Indigenous peoples in international law. She also serves on the United Nations Expert Mechanism on the Rights of Indigenous Peoples as its member from North America, and previously served as the mechanism's chair. Recently, Professor Carpenter was appointed as a justice of the inaugural Supreme Court of the Shawnee Nation. She has published extensively on these topics, and her articles appear in leading law reviews. She's served as Associate Dean for Faculty Development and Associate Dean for Research. She was a founding member of the campus-wide Center for Native American and Indigenous Studies at CU Boulder. You can find out more about Professor Carpenter's impressive background in the program. I'm now delighted to turn the presentation over to Professor Carpenter. Kristen.
Thanks, Dean Anaya, for the really kind introduction. And it's nice to see so many of you. I have a long list of people to thank, and I keep seeing more friends and colleagues joining the program. If you'll give me just a moment, I'm going to share my screen. Okay, great. I hope that you can see not only the PowerPoints, but also friends and colleagues who are on the Zoom tonight. So I did want to thank Dean Anaya in particular for being such a supportive teacher and mentor. He's a visionary and leader in the field. And he was my own professor in 1997, which is when I started to work on Indigenous peoples' issues from a human rights perspective. And he's been really influential in that way. I'd also like to thank Yesenia Delgado and Georgette Vigil for doing all of the work to make this event happen. With respect to my topic tonight, Race and Religion, a case study on Indigenous peoples in the United States, the work I do in this area also takes place with a great deal of support. And I'd like to acknowledge a debt of gratitude to some of the people on this call, some of whom are ceremonial people and leaders in Oklahoma, including Greg Bigler, Ben Barnes, and David Cummingdeer. Along with the entire team at the Native American Rights Fund. I think Brett Shelton and Don Ragona are on the call, plus Walter Echohawk and Heather Whiteman runs him. The NALSA students, whom I just love and admire, they've all been in my classes, Taylor Shad, Sasha Strong, Logan Big Eagle, and Ryan Lolar, and possibly others. Along with some former students, Amy and Daniel Cordalis, scholars Greg Johnson and Michael McNally, the entire American Indian Law program here, my co-author Angela Riley, my family, some of whom are on the call tonight, and really everyone for being here. Given that this is a topic that is sometimes sensitive and many Indigenous peoples keep issues of religion confidential or private, I also want to acknowledge that I'll err on the side of non-disclosure and keep those confidences where I have them. In the US, there are over 500 Indian tribes, each of which has its own religious traditions dating back centuries or millennia, whether we're talking about Pueblo feasts or the Haudenosaunee Longhouse, the Medewan of the Anishinaabe, Tlingit potlatches, or Cherokee stomp dances. These and other traditions link humans to their creator through songs and prayers, offerings and dances, many of which occur at unique places of origin or migration of the Indian people. These practices and obligations bind generations together with specific covenants to give thanks, cleanse the spirit, heal transgressions, renew relationships, and keep the world in balance. Often inscribed either literally or figuratively in the natural world, these traditions provide instructions for living in the world according to spiritual tenets and relationships. And so, for example, the San Francisco Peaks is Doko Slid to the Navajo people, one of the sacred mountains marking Dinata, their homeland. They say that this snow-capped mountain emerging from the high desert is adorned in abalone. It's a place that figures heavily in their creation story, the mountain where Changing Woman gave birth to the twins who are the ancestors of the Navajo people. And it's a place of contemporary prayer, of gathering plants. It's also one of the sacred mountains that's referenced explicitly in the fundamental law of the Navajo people, which specifies a duty of care to the place. For the Hopi, these same peaks are also sacred. The Kachina go to the peaks during the winter as clouds who in spring Ceremonies are celebrated for their return to the villages, bringing rain for the corn and life to the people in an eternal circle and cycle of life. Taking care of and worshiping perhaps at these places is something Indigenous peoples have been doing and have known how to do for eons. But the problem today is that following conquest and colonization by Europeans and later Americans, many sacred sites, along with plants and waters, are located outside of Indian reservations. So this is the flag of the Navajo Nation, and you can see in brown the outlines of the reservation, and the 4 sacred peaks are located outside of it. This is because when the Navajo returned from their long walk in the 4 years of imprisonment at Bosque Redondo in 1868, the treaty that they were able to negotiate did not include their sacred mountains within it. And so to a significant extent, Navajo people now lack the power, at least by virtue of land ownership or jurisdiction, to protect the San Francisco peaks. And therefore the ceremonies, the plants, the waters, and medicines that go with it. Across the world and across the country, I should say I've worked on these cases all around the world, but I'm focusing on the US cases today. The same situation is playing out in hundreds of places where the federal government or state governments or private individuals claim to own Indigenous people's sacred sites and wish to use them for development, whether oil or gas or copper or gold mining, recreation, or other purposes that would desecrate them for the tribes and make the religious use impossible. Friends in Oklahoma, and I know some are on the call, they will recognize the Achota ground that my son is named for. They've shared that some of their sites, which are perhaps not as well known from the media or from the cases, they too are vulnerable to traffic stops by local police when ceremonies are happening, to harassment that deters them from gathering the plants that they need for their medicines. And really, this is happening everywhere. So given that this is a law talk, you might know where this is going. And don't we have a law for this kind of thing? The First Amendment of the US Constitution, of course, provides that the government shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. This value of religious freedom, of free exercise, is one that's cherished by most Americans. There it is, enshrined in the very First Amendment to our Constitution. So along these lines, tribes have brought many, many cases over the years arguing that the free exercise clause should protect their religions, their ceremonies, their spirituality, their covenants, their sacraments, and so on, just like it protects everyone else's. Unfortunately, however, the Supreme Court quite stunningly has held that the First Amendment does not protect Indian religions. And so in Ling versus Northwest Indian Cemetery Association, the court held that the government could destroy a sacred site even if it would destroy the religion, so long as it did not coerce belief, for example, by denying a benefit or imposing a sanction, according to Justice O'Connor. This case concerns the Yurok people, and there's a picture of some Yurok children in their sacred lands at the time of a salmon ceremony. And then in Employment Division versus Smith, the court turned from sacred lands to sacred sacraments and held that in this case, the state government did actually deny a benefit, unemployment benefits to individuals who were fired from their jobs for taking the sacred sacrament of peyote. This too, though, was justified by the Supreme Court because according to Justice Scalia, the government was accomplishing this through a neutral statute of general applicability, thus evading First Amendment review. Now, you might wonder why I'm harping on these cases from 30 years ago. When I was running this presentation by my kids, they said those cases were decided in the 1900s, which of course seems really recent to me. But the unfortunate reality is that even though the Supreme Court has in recent years become much more solicitous of many religions, it hasn't become more solicitous of American Indian religions. So literally last Friday, a federal district court in Arizona considered a case in which Congress has decided to swap Apache lands, traditional lands, now managed by the US Forest Service, to a foreign mining company that will use them for copper drilling. This is a place where Apache young women have their coming of age ceremonies. It is a unique site. And they, of course, have tried to use the First Amendment and other laws to seek legal protection of their sacred lands. And the district court, and everybody's just reading this opinion now, the district court wrote, the land in this case will be all but destroyed by the mine, and Oak Flat will no longer be accessible as a place of worship. And then going on, the mining plans will have a devastating effect on the Apache people's religious practices. But even that doesn't violate the Constitution, according to the federal district court, because of that Ling case, because the federal government has the power to destroy Indian sacred sites somehow without violating the First Amendment. And so, notwithstanding the First Amendment, what happens in case after case is that sacred sites are desecrated. They lose their physical integrity in ways that are sometimes minor, sometimes major, but nonetheless very poignant to the American Indian religious practitioners. So how did we get here in a country that so values religious freedom, but doesn't extend it to American Indians? And here I'm going to go a little bit back further in history, and I'll try to make it brief. But these are pretty important things, I think, to know. So back in the 1700s and 1800s, settlers and eventually our government thought that Indigenous peoples had no religion. In instrument after instrument, whether it was the report of commissioners or the opinions of cases, our legal institutions called Indigenous peoples savages, infidels, and pagans, and it used these statements as justification for their dispossession of lands by Christian people. And this is how the court in the fundamental case of Johnson versus McIntosh, which all of my students have read, legitimized the taking of Indigenous lands. And of course, this included sacred sites. But not entirely content with this mode of conquest and colonization, our government also turned more specifically to religion, and over hundreds of years passed laws and programs outlawing Indian religions, requiring doctrination of Indian people into Christianity, digging up Indian cemeteries, even killing Lakota people in 1890 while they prayed, while they were in a ceremony. All of this was thought by the government to be necessary to assimilate Indians into white society. For those of you who are Establishment Clause scholars, you might be interested to know that in the late 1800s, the government was using the money that it owed tribes for land cessions to fund Christian reservation missions to reservations. And somehow this didn't violate the Establishment Clause and has never been remedied. Needless to say, this was all devastating and harmful to American Indians who were jailed, lost treaty rations, punished physically in boarding schools, and otherwise harmed for practicing their religions. Many of the religions went underground. Some practices sadly have been lost altogether. Around 1900, both Indian religions and Indian populations reached their low point or their nadir. But the 1900s have witnessed a period of recovery, of revitalization, and self-determination of the people and their religions themselves. And so many of our heroes, John Echo Hawk from the Native American Rights Fund, Suzanne Harjo, Reuben Snake, Walter Echo Hawk, are among those who were advocating in the 1960s, 70s, 80s, and so on for legislative remedies to this history of suppression and oppression of American Indian religions. And finally, and not till 1978, did Congress repudiate its previous policy prohibiting Indian religions. So not until 1978 did it become legal for American Indians to practice their own religions. And this American Indian Religious Freedom Act was critical because it did state affirmatively that it's the policy of the United States to extend religious freedoms to American Indians, things that you might have thought would go without saying given the First Amendment, but obviously didn't. And this was a monumental achievement, but unfortunately, as you can probably glean from our discussion of Ling and Smith, it didn't fully remedy things. The courts held that ARFA, this American Indian Religious Freedom Act, had no teeth to it. And even if it was federal policy to allow Indian religions, there was still no legal action to protect them. But Indians could not give up. They have these ongoing ceremonial obligations. And through their advocacy, some legislative accommodations have been achieved. So in 1990, Congress passed NAGPRA, the Native American Graves Protection and Repatriation Act, requiring repatriation of those human remains that had been dug up by, from their graves to be repatriated to tribes for reburial, among other things. In 1992, Congress passed amendments to the National Historic Preservation Act, requiring consultation with tribes for actions that would adversely affect sacred sites. There have been other legal legislative amendments to allow for the possession of eagle feathers and peyote in limited amounts, and some agreements, memoranda of agreement between federal land management agencies and tribes regarding, for example, Bear Lodge here, so that during times when ceremonies are happening, some of the recreation or development activities won't take place. And I should acknowledge that many of the attorneys, I saw Roger Flynn on the call, and Don and Brett, Jim himself, have argued these cases for decades. And I'm in the lucky position of being able to talk about them. And I too have litigated and appealed some of them. But this has truly been a community effort. And those victories in the 80s and 90s and 2000s are incredibly important, but they're also limited. And in 2016, we saw kind of the, high point, low point of these limitations when in the famous Dakota Access Pipeline case, the Standing Rock Sioux Tribe and the Cheyenne River Sioux Tribe objected to the federal government's decision to allow construction of an oil pipeline through sacred sites, burial grounds, and under their sacred waters adjoining the reservation. And much like in the image I showed you of the Navajo reservation, these sacred places are outside of the boundaries of the Sioux reservations, but in this case, only because the treaties were affirmatively violated and have actually not been remedied in a meaningful way, at least until this day. So once again, you're probably becoming familiar with the story. The tribe sued, right, under the laws that we've just described. This violates our religious freedom, our historic preservation, et cetera, et cetera. But the courts held that the federal agencies had met their minimal legal obligations, that they had consulted with the tribes. And although there is this right to consult, it doesn't obligate the agencies to pay attention to what they learned during the consultation. So in case after case, an agency, the Army Corps of Engineers here, will say, oh, well, we listened to the tribe about their sacred sites or their religious freedoms, but we decided to go ahead with the plan anyway. And this is legal under current law. And also because, of course, Ling still allows for the destruction of sacred sites. So the project went ahead. But this is one of those cases where I think the failure of the law is just so poignant. And what happened next shows that it's failing not only Indians, but all of us. The decision in Standing Rock was unjust. And when the courts failed to protect the religious freedoms, thousands of people, not only from those tribes, but from all over the US, and thousands of Indigenous people from all over the world and other allies went to North Dakota and camped out, putting their voices and their bodies and their lives on the line to protect this site. And my mom is smiling there because she remembers when I went to North Dakota and showed my solidarity. And I know many of you on this meeting were there as well. I wasn't on the front lines. The people who were on the front lines, though, were being attacked by local, state, federal, and private law enforcement and security. Water cannons were used on them, explosives, dogs. People ended up with lost limbs. They went to jail. They lost their liberties. And ultimately, political power and economic power did prevail, and the pipeline was built and the oil is flowing through. But it cost a lot. It cost a lot for everyone. The oil pipeline company, Dakota Access Pipeline, lost millions of dollars. Everybody lost face. All of the governments involved looked terrible. Indian people felt as if they are not equally protected by the Constitution. And 5 years later, this case is still in the courts. So it turns out that Americans, Native American and otherwise, care really deeply about religious freedoms. And for the government to prohibit those religions or destroy them is not a functional practice anymore. I'll say just briefly before I turn to a quick discussion of some remedies, and the dean gave me 35 minutes to speak, so I think I'm still doing okay, but he can cut me off if I go over my time. But for a while, many of us thought there was some hope in the Religious Freedom Restoration Act and the Religious Land Use and Institutionalized Persons Act of 1993 and 2000, I think I have the date wrong there, respectively. And this is what I alluded to at the beginning of the talk, that while Indian religions remain unprotected by the First Amendment, Congress and the courts have been expanding protections for other religions. And so, for example, you may know that following the Smith case, where Justice Scalia had essentially killed the test for a burden on religion, the substantial burden compelling interest test, Congress decided to restore that test through legislation, such that even if it's a neutral law of general applicability, if the government does burden somebody's religion, Congress has to show a compelling interest in that activity. And the courts have really interpreted RFRA pretty broadly. So RFRA under the Hobby Lobby case protects the right of corporations to their religious freedom. Who knew that corporations had religious freedom? More recently, in the Little Sisters of the Poor case, RFRA justified an administrative rule exempting that organization from federal law. There have been decisions protecting bakers, churches that don't want to hire women ministers, people who don't like filling out forms, all on grounds of their religious freedom, as has been restored under RFRA. But as we just saw in the Apache case, and we saw a decade before in the Navajo case, RFRA, like the First Amendment, offers no protection for Indian tribes from federal development of sacred lands because, again, Ling. So even this legislation that we thought might help hasn't. So I'll fast forward. At this point in the story, I'm getting old. My clients are getting impatient, and nothing has changed, essentially. And this is what led me to international law, exactly this problem. When Indian tribes run out of options in the United States, but are still just as committed to their religions and their life ways, they want their lawyers to go further. They need a remedy. And I was hitting those brick walls, both in child welfare cases and religious freedoms, and started to look back at the studies I had done with Dean Anaya and opportunities to work on these issues in international settings. And my work at the United Nations has allowed me to do that. So while I've looked at human rights as they apply to all sorts of issues facing Indian tribes, I'd like to offer a few minutes of focus about Indian tribes in the religious freedoms context and how a human rights approach might possibly help. So when you look at the Universal Declaration on Human Rights, recall that it was 1948 when the world got together just post World War II, after the Holocaust, when the fact of being a vulnerable minority religion is what led 6 million Jews to lose their lives. And the world community got together and said, never again. All human beings are born free and equal in dignity and in rights, and everyone has the freedom of religion. Now, this articulation of the freedom of religion in the Universal Declaration is a little bit different than our First Amendment, as you can see from the language alone. And it includes the right to believe, to practice, and worship in public or private. Now, in the US, I didn't go into excruciating detail on the Ling case, but one of the things that Justice O'Connor said was that even if the government destroyed sacred sites, individual Indians could still keep this private core of belief. They could still believe this place was sacred, it just might not exist anymore, or it might be bulldozed. And there is this distinction in US law between belief and practice. But under international human rights law, while those different factors are recognized, they are all protected. And whether it's occurring in public or in private, it too should be protected, which is critical in the Indigenous people circumstance, given that so many sacred sites have left their private ownership. They are in public places, and religion must be practiced there. So my next question in this inquiry is, are Indigenous peoples also entitled to equality, to religious freedoms as envisioned by human rights, by the entire world community? And the short answer there is yes. In 2007, the UN General Assembly adopted the UN Declaration on the Rights of Indigenous Peoples after decades of advocacy by Indigenous peoples, who wanted to illuminate the ways in which the Universal Declaration and the several treaties that put its provisions into practice, how do those apply in the Indigenous peoples context? Because it's not just in the United States that Indigenous peoples have been discriminated against, it's all over the world. And 144 nations ultimately voted in favor of the UN Declaration on the Rights of Indigenous Peoples, which recognizes the equality, the self-determination, the individual and collective rights of Indigenous peoples, like everybody else in the world community, but also expands upon how those rights should play out in Indigenous peoples' contexts. And this is the part of the talk where if we were in person, I would hand out copies of the Declaration. I kind of want everybody in the world to carry one. I have one in my purse next to my US Constitution and my passport, which of course I no longer use because like everybody else, I'm trapped in my basement. But this is an instrument that contains 46 articles elaborating a vision for Indigenous peoples' human rights. And it has quite a few provisions on their religious freedoms. And forgive me for the text-heavy slides, but again, I couldn't pass out the actual declaration. So I'm just going to mention a few of these and then talk about how we could put them in place in the US, and then I will adjourn for your questions. So one important thing about the declaration is that it has both remedial and ongoing provisions. It recognizes these histories of oppression and dispossession that Indigenous peoples have been through, and it requires states to provide remedies. So for example, with respect to all of those sacred sites that have been taken without the free, prior, and informed consent of Indigenous peoples, or in violation of their laws, customs, and traditions, of which there are hundreds, the declaration provides that states, like the United States, must provide restitution, must return those sites to the tribes involved, or find some other way to effectuate restitution, whether that is joint management or some other way to ensure their access and their ability to practice their religion there. Article 19 is also helpful. It provides that states must cooperate and consult with Indigenous peoples in order to obtain their free, prior, and informed consent before measures affecting them. So in all of those cases where I mentioned that administrative agencies are consulting with tribes, but then going ahead and desecrating their sacred sites anyway, the declaration would envision something different. It would envision negotiation, participation, and mutual agreement between the land management agencies and the tribes on the treatment of those sacred sites. And then Article 25 provides, and it's really specific as to the spiritual relationship with traditionally used lands of Indigenous peoples, whether those are now owned or not, and the fact that spirituality can be found in the natural world, and also that Indigenous peoples have obligations to future generations to protect those sites. I'm going to go ahead so we can get to the punchline here. So the idea overall, and I think, challenge for my generation and the next generation, following on the heels of those who drafted, negotiated, and got adopted the Declaration, is how to implement it, how to reform the law we have in the United States to reflect the world community's consensus on Indigenous peoples' human rights. And this is where I'd like to give another shout out to the Native American Rights Fund. The University of Colorado's American Indian Law program, together with NARF, has developed a program to implement the Declaration here in the United States. And through my UN work, I know that implementation is the name of the game worldwide. Canada has passed legislation, New Zealand is working on a national action plan, countries all over the world are trying to figure out what we're also trying to figure out here in the United States. How do we do a better job? How do we reform our law to ensure the rights of Indigenous peoples? And we have this joint project where attorneys and students and law professors and community members are all getting together to think about how to address these problems. We're producing toolkits and other materials, litigation strategy, legislation strategy, you name it, we're on it, but it's a long-term project. So a few specific ideas that we could use to put the Declaration into place here. The first is when it comes to legal cases, judicial cases, like the Apache case we just talked about. The federal courts could consult the Declaration as an interpretive device for understanding how the First Amendment or RFRA should apply in these sacred sites contexts. And this is a strategic move, one of many things that I've learned from Dean Anaya, who in his human rights casebook and in many, many talks he's given, has talked about the fact that the Declaration represents the world's community's consensus on rights for Indigenous peoples. It should be brought to bear on legal instruments that we have, not only internationally, but in the United States too. And in other instances where the Supreme Court, for example, has tried to figure out, well, what's the right constitutional approach to the juvenile death penalty or other fundamental issues? The Supreme Court has looked to the standards of the world community. And I think this is one of those instances where the courts could do exactly that. And when you look at the Declaration and you see Article 25 saying that Indigenous peoples have a right to a spiritual relationship with their traditionally owned lands, that could help courts understand that, to be blunt, the Ling standard is just wrong. It's unconstitutional. It prevents Indigenous peoples from practicing their religion. Destroying a sacred site is burdening the religion. That must trigger under RFRA the compelling interest, least restrictive means test. So this is something that courts could absolutely do. The Declaration is available to them. A bunch of us are working on briefing in the Jimenez Pueblo case that is citing the Declaration. It won't be too long, I think, before the Declaration comes to inform land rights and First Amendment rights and RFRA rights, hopefully, in the courts. We could also look to the Congress and the agencies and take that provision on free, prior, and informed consent and use it to bolster that really weak standard of consultation where the agencies talk to the tribes, but they go ahead and do what they want anyway. We could amend the National Historic Preservation Act to require those consensual agreements, to take best practices where there have been agreements, and actually make that a legal requirement. Some agencies we already see moving in this direction. The Advisory Council for Historic Preservation has adopted the Declaration as a matter of internal policy. And many of us following the Biden campaign, transition, and so on, are working on these issues in national advocacy. With respect to the articles I mentioned that have that remedial effect, there are lands where actual restitution is a possibility. Richard Nixon, perhaps an unlikely champion of Indian rights, knew this as far back as 1974 when he led at least from the government's perspective, the effort to restore to Taos Pueblo their sacred Blue Lake through federal legislation. There are other places where federal legislation or executive orders or whatever mechanism we want to use could be restored, especially because those lands are still within the public domain. And we have a good example, a place of spiritual and theological practice that's kind of at issue right now, Bears Ears National Monument, which was set aside, I think 1.8 million acres by the Obama administration, and then retracted by the Trump administration, and now under reconsideration by the Biden administration. This is a place where exercising that principle of restitution, as well as creative strategies for cooperative management, could help to effectuate Indigenous peoples' religious freedoms. And I should acknowledge our colleague Charles Wilkinson and the Native American Rights Fund, who again have worked tirelessly on this. For those of you in Boulder who are asking, what can I do? This picture on the right is Valmont Butte, which is a sacred site in our own town. It's a sacred place to many of the Plains tribes. It has long been desecrated by mining tailings and various other uses of the land. This is a place where we could all take the declaration and advocate for protection of the site, for access by Indigenous people. The Lakota caretaker was required to move from there not too many years ago. This is something we can do, something we could actually work on here. And in closing, I'll just say, this is a tall agenda, perhaps, but it's also possible. I really have come to reject the idea that reform in this area is impossible. But it is going to require monumental effort and really serious commitment. I appreciate the chance to share these thoughts on Indigenous peoples and religious freedoms as part of the Race and the Law series. And I hope we can all work toward human dignity, better relationships, and respect for the sacred going forward. And with that, I will close. Thank you.
Thanks so much, Professor Carpenter, for a really illuminating presentation. You've really touched upon some important issues that are felt by many on this Zoom call, I'm sure. So we'd like to now invite attendees to submit questions using the chat function, and I believe our students will moderate the question and answer. I'm not quite sure, but anyway, unless you tell me otherwise, I'll go with that.
Yeah, we'll start to moderate. So on Petu Washte, first of all, I'd like to give a big Wopila Tonka to Professor Carpenter for that wonderful and insightful talk. You have definitely given us a lot to think about and a lot to talk about for the remainder of this discussion. So just as a quick reminder, my name is Taylor Shad, and I am the president of the Native American Law Students Association here at CU Law, and I am joined by Sasha Strong. She's the vice president of NALSA. So we will be the moderators for the Q&A portion of the event. So just like what Dean and Naya said, if you have any questions, feel free to use the chat function, and we will ask them as we receive them. And with this, Sasha has the first question for Professor Carpenter, I believe.
Bonjour, hello, my name is Sasha Strong, and I'm really happy to be here, and thank you so much, Chimigwech, to Professor Carpenter for that wonderful lecture. I'm happy to be here with Taylor as well. So our first question is, the UN Declaration of Human Rights, Article 27 says, everyone has the right to freely participate in the cultural life of the community, to enjoy the arts, and to share in scientific advancement and its benefits. Do you think the Declaration of Human Rights might be inconsistent or in conflict with religions and cultural privacy protections of UNDRIP, like those referenced in Article 12?
Great question, Sasha, and thank you for that. I have been thinking a lot about privacy, and sorry, I have my cat meowing in the back. It's the perils of Zoom. hopefully he won't jump on the table. But yeah, so I think just to kind of state what I understand to be the question, on the one hand, the UN Declaration speaks to Indigenous peoples' privacy interests in their ceremonies and religious sites. And that's absolutely critical, partly because of the historical situation where tribes have lost ownership of their sites, which are now in the public domain, but still those ceremonies require privacy or quiet, much like an attitude of reverence of being in a church or another religious site. And it's hard to accomplish that on the public lands. And I'll say, just sort of as an aside too, some of the religious freedom scholars who would argue that religion should stay out of the public sphere and only be in the private sphere, aren't really thinking about our challenges in the Indigenous context where so many sacred sites are on the public lands. If religion is only in privacy, that means it doesn't exist for many Indigenous peoples. But then I hear you on the other side, Sasha, with respect to the Universal Declaration and a universal right to participate in the cultural life of the community, and whether, and tell me if I'm not totally understanding, but I think you mean, would this limit the ability of tribes to exclude others from their religions, from their sites and their practices? And I think this is an area where accommodation and negotiation can really go hand in hand. I don't think it's the case that every single human being in the world should be entitled to attend Indigenous peoples' religious ceremonies. There are norms of practice and observance that pertain in these situations. And in some of the good examples, like at Bear Lodge National Monument, the way that the agencies have dealt with that is to say, okay, there's a certain time of the year, the month of June, when Lakota and other Plains ceremonies are taking place. The American citizenry can use that site all of the other 11, 12 months of the year, but during that time, we're going to close it off. So I think there's some balancing that can be achieved through those provisions, though I hear you on the potential tension.
Thank you for that. So the next question kind of goes back to the case law that you spoke about. So were the adverse Supreme Court decisions issued by a divided court? And does the current court offer any hope for reversal of the adverse decisions?
Yes, those decisions were issued by divided courts. And I'm glad you brought this up, Taylor, because it gives me a chance to talk about Justice Brennan's dissent in the Ling case. And there was a really powerful dissent where Justice Brennan essentially said the majority is making a mockery of religious freedom of the First Amendment. You cannot simultaneously destroy a sacred site and protect an Indian religion that relies on the sacred site. One tricky thing is that the composition of the court has so much changed since the 1980s, since the 1900s. And it's a little bit hard to read the tea leaves. Things are really changing in Indian law litigation, as so many of you know. For a while, I think we were trying to stay out of the courts altogether because there were so many losing cases, and our Supreme Court project, involved a lot of strategy on those points. But some of that has just briefly started to turn around a little bit, in that tribes are prevailing in some of their cases before the court, especially on treaty rights. And perhaps this is a really optimistic view, and I'm not sure I believe it, but the really optimistic view is that some of those same justices who believe in treaty rights are also sufficiently concerned about religious freedom that maybe they will decide in favor of the tribes if any of these cases reach the court.
Sorry, my mute button wasn't working. So the next question is, has the US signed on to UNDRIP?
Yes, this is again where I'm going to channel my best Dina Naya, who taught me these things when I was a student. So a government can't actually sign a declaration. A declaration is a resolution of the UN General Assembly, and it can be voted on by the member states, the 193 member states, which did happen in 2007. And the United States was one of 4 countries that voted against the declaration, which was, of course, disappointing to so many of us in this field. But in 2011, the US reversed its position, and so did the other 4 outliers, and expressed support for the declaration. And even with all of the, kind of crazy things that happened over the last 4 years, President Trump did not withdraw support for the declaration. The United States is still on record supporting the declaration. And in 2014, the United Nations outcome document from the World Conference on Indigenous Issues had a consensus, a unanimous document of 193 countries all agreeing to work on implementation. So I take all of those things as signs that the United States is on board, and it is up to the government and up to us as advocates to make those promises real.
So the next question that we have from the chat, it says, I'm wondering what you think the difference is between other countries and the United States of America in terms of racism and oppression, and maybe like kind of focus that on, the religious aspect of, especially in regards to American Indians.
That's such a broad question and a good one, but I do have, some comparative observations from my work over the last few years. On the one hand, and I think I'll just mostly talk about Indian tribes because it's probably too broad to talk about all racial groups, but in some regards, American Indian tribes are well empowered in the United States. Especially in the realm of jurisdiction over their retained lands. And there are some places around the world where tribes are really striving for, or Indigenous peoples are striving for that kind of recognition of their sovereignty and also their jurisdictional powers. But then on the flip side, when it comes to recognizing the significance of Indigenous people's own land tenure, and the standard of equality that should apply to Indigenous people's land tenure versus other people's land tenure, there are other countries, especially in Latin America, that have gone much further than we have in the United States. I didn't mention the Tehitan case. It's still the fact in the United States that Aboriginal title, that is Indigenous people's own land tenure, is not protected by the Fifth Amendment of our Constitution. So it's kind of 2 strikes. The First Amendment and the Fifth Amendment don't fully protect Indian tribes. Other nations, Brazil, Nicaragua, a number of countries in Latin America have held that that's unjust, that Indigenous people's lands must have the same protection as non-Indigenous people's lands. So in that respect, I think the United States has still got a ways to go.
Thank you for that answer, Professor Carpenter. The next question that we have is, do you think there are implications for climate policy in that Indigenous land stewardship has been recognized as a potentially important source of carbon sequestration? Would it make sense that combining interest in protecting sacred lands with another international priority could increase the odds of action being taken?
Yes, absolutely. And we were really encouraged in the fall of 2019 when the High Commissioner for Human Rights, in her annual statement, which is, surveying human rights all around the world, she noted that Indigenous people's interests in their lands are a key component to combating climate change, not only their interest in their lands, but their traditional knowledge with respect to adaptation to respond to the challenges of climate change. And I think, so internationally, and there's a new local communities and Indigenous peoples platform within the United States that I think is looking at that intersectionality of Indigenous rights and addressing climate change. Here in the United States, some of the tribes, and I'm not sure if they're on, but again, a shout out to my former students who are working at the Yurok tribe. They're in this, wide ranging project to use land recovery, reforestation, and the climate, the market for carbon to restore an economic and an environmental basis on and around their reservation. So I think both internationally and in the United States, and there are really good examples from Brazil and so on, where you could see some intersectionality and mutual progress in this regard.
Perfect. So we have time for one more question.
Great.
So what are tribal legal groups working on in regards to amending some of the federal legislation so as to give equal protections to tribal and native religions?
Well, that's such a good question. And so many of us on this meeting have been on a lot of those strategy calls. And I think I'm just going to share my own view versus what tribal legal groups are doing, because I don't want to speak for anybody about their own approaches. But a couple of things. I mentioned the National Historic Preservation Act. For me, that would be the most immediate source of or opportunity to reform, and just simply to amend it's not that simple, but to amend the 106 consultation process to require consent between agencies and the tribes. And I think there are great models in that regard. I mean, there are other vehicles. The American Indian Religious Freedom Act could also be amended given that it was amended to provide protections for the peyote religion, it could be amended also to deal with some of these other issues. In terms of federal statutory approaches, those are the two that I guess I would like to focus on. I know that there are others who are working on federal environmental statutes and may have ideas along those lines, FLIPMA and NEPA and all of those. As I mentioned too, though, I think the agencies themselves can do a lot of internal policy reform, issue their own guidelines, and those could almost be like building blocks to legislative reform. We could see how it goes internally. And again, I think the existing statutes like RFRA is totally fine. It's a great statute, but if it could be interpreted to protect Indigenous religions along with other people's religions, it doesn't really need to be amended. It just needs to be applied more fairly and more inclusively.
Definitely. So thank you so much again, Professor Carpenter, for the eye-opening presentation. I imagine your presentation has prompted meaningful dialogue for the breakout groups. By the end of the week, you'll receive an email with the link to the presentation and a survey to share your thoughts and feedback. And Colorado attorneys will receive a link for the CLE affidavit as well. So stay tuned for further information on this. But now you will be moved to the breakout sessions. And please note that you'll receive a 2-minute warning when the session is over and this interactive session is complete. So thank you again, Professor Carpenter, for really for amazing lecture and presentation.
Thank you, Taylor, and thank you, Sasha. Can I say one more thing before we break out? So Taylor was part of a group this summer that worked on the project to implement the declaration, and she wrote the Religious Freedoms chapter in which she surveyed what tribes themselves are doing. And a number of tribes that have themselves embraced the declaration and advanced the ball in this regard. And Taylor's own research, along with Sasha's and the other students, is the next generation of work in this area. And so I wanted to recognize that too. Thank you. And Sasha's writing a paper right now on this topic as well. So we've got a lot going on. Okay, I'll be quiet. Thank you.